Hello, it's Philip Taylor speaking from Richmond, Green Chambers in London, and today I'm looking at a book which has come to us from Wildy, Simmonds and Hill Publishing. They have commissioned this second edition of an excellent practitioner's guide. They have a series of them. This one is on what they call probate disputes, sometimes known as by various other names, but contentious probate is one that raises its head occasionally. This is the second edition. The book's been written by Nasreen Pearce, who will be known to many of you as a first-class expert in this area, a retired circuit judge, ex-district judge. I've given the review a welcome updated second edition to probate disputes for 2022 and beyond. It's a difficult area of law. I've done some cases and some hearings in this area, and it does bring out a very bad side of human life, I'm afraid. That's one of the problems of this area. There's the book anyway, nice blue cover, and then you've got the spine, and then you've got some blurb on the back, which I shall use partly in the review. Let's just go into it. It's a hardback book, as you can see from that. And you've got an index at the back. It's by page numbering. We'll see right at the back. It's not a particularly big index. References are to page numbers, it says there. Then you've got right at the back various annexes to various bits and pieces concerning guidance, practical guidance. It is very much of a practical book. Examples of various, this is for instance an example of undue influence to be set out in the particulars of claim. Quite important, because that could well be an area of substantial contention. There's the front page of the book there, and then after that you've got the blurb on the side about the book. Then you've got the contents section. It's easy to navigate, not difficult to get around. You should be able to find what you're looking for in this particular index, or rather the contents section, which can be read with the index at the back. As you can see, there are in fact 16 sections. And then what you've got is the appendices at the back, split into 3 parts, then the index after that. Then you've got, in addition to that, the table of cases. Quite a few cases involved. Then after that you've got the table of statutes. Then after that you've got statutory instruments. All the usual ones are there. And then after that you've got some conventions, EU regulations and so forth. Again, I know we've left the European Union, but there's always going to be some stuff that comes in, and that's going to be around for a long time. Then you've got an introduction, and it starts off really very much. Disputes over wills and inheritance have been soaring since 2006, and it gives the percentages. And as I've said, the ones can be very bad-tempered. There can be some really nasty allegations and really quite serious unpleasantness between family members. Obviously, Nasreen gives an example. There are many reasons for the rise. In some cases, the disputes arise because of intestacy, others because of poor drafting wills, and so forth. But generally speaking, there's a lot of contention, unfortunately. So we start off with the introduction, then we have, you can see how it's structured. You've got paragraph numbering there. Generally speaking, there's no footnotes in this particular book, but as I say, the paragraph numbering itself is quite helpful, because as you can see, each paragraph, that's the end of chapter 1, so the paragraph is 1 point whatever, and then likewise chapter 2, 2.1 and so forth. We're starting with an introduction and then running through. But I think you should be able to find, depending on what your issues are, you should be able to find what you want in this book. I think it should be something a lot of people should look at before they start wishing to launch either proceedings or even mediation for that matter, because this is a very difficult area, and as I've said before, it brings out very nasty points of view and behavioural issues from the parties, because it's dealing, of course, with the property of a dead person. And that's really one of the reasons, because that dead person can't come back and have a discussion with them about how they feel about things. And I say that because of some of the cases I've had, and some of the quite surprising behaviour patterns seen So what I say about this, let me say first of all that Nasreen Pearce is a retired circuit judge and was formerly a district judge at the Principal Registry of the Family Division. She's also been the general editor of Butterworth's Wills Probate Administration and has done a great deal of professional writing as well. Obviously the Principal Registry of the Family Division, which is what we've got there, is actually that is now the Central Family Court with the rearrangements, and a lot of changes are taking place within family law anyway. But let me talk about this particular book because it remains, in my view, an invaluable guide to the relevant legal framework and the basis on which a will and other testamentary provisions can be challenged. And as I say, you do get some unfortunate things cropping up when this happens. The second edition, which Nasreen has set out and worked very hard on, details the issues that personal representatives must deal with, including grounds for their removal and replacement, lifetime testamentary dispositions and claims, the challenges that can be made in relation to them, and the new measures introduced in relation to the execution and in attestation of a will, which has actually resulted from the COVID pandemic, which have caused obviously a great deal of difficulties. And what it also does, which I think will be very interesting for many, is it specifically covers wills procured as a result of fraud. And there are unfortunately quite a lot of instances of that taking place from time to time. And obviously there is some very useful guidance in the appendices at the back on what you might be putting into your particulars of claim. What in fact Wildy's, when they commissioned this book, they wanted to do was to supply guidance as to the best practice, and therefore they've set out examples from recent case law to illustrate the legal requirements and the problems which can arise from poor will drafting and a failure to investigate sufficiently all the circumstances relating to a testator and or their capacity to make a will. And those issues can crop up quite regularly. And as I've indicated before, there are these do-it-your-own wills which can also cause a great deal of difficulty. My own advice is always go and see a solicitor and get it done professionally, and therefore they will know what to include within any form of drafting. Finally, let me say that what you've got with the new second edition are new chapters which include matters such as burial disputes and personal representatives. And I've got a case at the moment involving a personal representative, and again, I think it's quite useful to have some guidance because you're dealing with people at a very difficult time in their lives quite often, and therefore it's important to know what the do's and don'ts are in any particular situation. There's also a chapter on procedure for making applications, and what Nasreen has done is expanded that to include pre-action steps and disclosure generally, provisions for disclosure generally, so thank you for that. There's also a comprehensive commentary on liability for costs, which has been included at the end. Now, the date of publication of this new second edition, the hardback edition, is cited as at the 31st of March 2022, so it's relatively new. I'm recording this in the spring of 2022, and obviously I believe it's a very useful book for anybody involved in this area. Let's have a quick look at it again. It's the front, there's the spine, and then there's the back. And if I open it in the middle somewhere, property held as joint tenants. 12.1.2, an important area, believe it or not. That can cause a problem. Severance of joint tenancies. We're getting heavy land law stuff here for those of you who hated it all those years ago. But you can see it's an important point because you have to think about what sort of interest people have in the land or did have. So chapter 12, jointly owned assets and assets held on constructive trusts. And in fact, a constructive trust is quite often, remember, the constructive trust is created by operation of the law by the courts. As I say, I've got a case involving a potential constructive trust at the moment because, again, the court can use a mechanism, depending on if there's, remember, express or implied trusts, You can have constructive trusts. And then if the court comes into play with that sort of thing, again, you're going to have all sorts of disputes. But at least you've got some indication. You might be able to advise your client as to where the case might be going. Because as I've said, one of the problems is sometimes they will be arguing about relatively trivial sums of money, and before you know where you are in the contentious probate issues, the money's all gone because they've been rowing amongst themselves, and that clearly was never the intention of the testator in the first place. However, that's all a matter for individual cases. I'd like to thank retired Judge Pearce very much indeed. Really great to have this expertise given to us. These books make our lives a lot easier, and I can't stress enough thanks as a practitioner, and I know that comes from many of my colleagues and also from unrepresented parties as well. These books make a difference, and I'm very grateful to review them. Thank you all very much for the work you've done. Bye-bye.